Okay, well, thanks very much, Josh and Sandra, and I saw Sean earlier today. Everyone who has invited us here for this, what I've been saying to everybody up here, this is an all-star conference. I mean, from today, tomorrow, I'm literally going to get up like at the crack of dawn to be here for the first panel tomorrow morning because it's just fantastic. And it's also Old Home Week because we all, know each other, get a chance to see each other. So with respect to this particular panel, copyright in the individual, and as we began to have conversations amongst ourselves as to what we wanted to talk about on this panel, one thing just immediately stuck out to me, and that was that looking at the title, although the title says copyright in the individual, looking at we each were thinking about, as I asked them, okay, what do you want to talk about? It was obvious to me that we all looked at it, and what was going on in our heads was we were thinking about this as copyright in service of the individual. And as you'll hear from everyone's remarks, you'll see that for most of us who deal in this space, that is not only our perspective of copyright, but basically our expectation of copyright. And I think that in some ways, some of what we'll be able to deal with here today is, to a certain extent, the fact that some significant portion of the public just has a completely different perspective of that, right? That not only copyright, but IP in general, it is the way in which individuals are, what's the Latin for it, screwed, right? It is the way in which only wealthy corporations get to enjoy the fruits of individual labors, and many everyday people would look at copyright in service of the individual as something of an oxymoron, like IP social justice. But that's another conversation for another panel. So with that, I am going to introduce and then turn it over to our four eminent panelists. We have with us today Rachel Kim, who is the Vice President and Legal Policy and Copyright Counsel for the Copyright Alliance. Michael D. Murray, who, let me push this back a bit, who is the Spears Gilbert Associate Professor of Law at the University of Kentucky, the J. David Rosenberg College of Law. Mary Rasenberger, CEO, Authors Guild and Authors Guild Foundation. And last but certainly not least, Jeff Sedlick, who is the Chief Copyright Advisor and President Emeritus of the American Photographic Artists President Plus Coalition, Director, Copyright Alliance, and Professor at the Art Center College of Design. And so with that, you're going to see how when we were having the conversation as to what this panel, how it was going to be structured, literally after they each indicated what they were going to talk about, there's this incredible linear spectrum of ecosystem copyright service that just emerged. And the planning session, and these guys will back me up, we planned a half an hour. It took us like, what, maybe really 8 minutes because it just assembled itself. So I was telling them that when they're not looking, I'm actually going to sneak off of the play. I'm not needed. These guys are going to cover it. So let's start with the beginning of that spectrum with your remarks, Rachel.
Sure. Is this on? Okay, great. So hi, my name is Rachel Kim. I'm VP of Legal Policy and Copyright Counsel at the Copyright Alliance. We're a nonprofit education advocacy organization in DC. We represent over 15,000 organizations and over 2 million individual creators, all who depend on copyright law to create and continue their professions. And so with that being said, I am here in my personal capacity, so any views I kind of espouse today are not necessarily reflective of any individual Copyright Alliance members. That being said, I really like the topic of this panel. Oops. As Lateef mentioned, I think there's so many different ways to tackle this. And the perspective I wanted to bring to the panel today I wanted to focus on sort of copyright registration and what that means for the individual. So, when we talk about copyright law and just IP law in general, we always harken back to, Article 1, Section 8, Clause 8 of the U.S. Constitution. But I think it's really important as a setting for our conversation today because it really, does highlight that the public good is benefited by the grant of exclusive rights to authors and individuals. It enriches the lives of individuals across society through individuals. That's what copyright law is really about. And I wanted to tackle copyright registration today because I think it's a really good barometer to measure whether our copyright laws are indeed making that positive impact on the individual, serving individuals in society through individuals. We know that copyright protection is automatic once an authored work is fixed in a tangible medium. But the copyright owner gains some important benefits by registering the work with the Copyright Office. So having a work registered means that a court can award statutory damages, which was referenced to by Terry Hart on the first panel. It gives the copyright owner presumption of copyright validity. It enables the copyright owner to sue in federal court to enforce their rights or file claims with the Small Claims Copyright Tribunal, the Copyright Claims Board. So registration is a really important entry point for authors to fully protect and enforce their rights, and it's often a creator's first interaction with our federal copyright system. And we saw registration play in a really important role. I know we're going to talk about AI, or not me, but others are going to talk about AI tomorrow morning. But we did see registration play an important role in some of those 20-plus lawsuits brought by creators and copyright owners against AI companies' unauthorized use of copyright-protected works to train AI models. So we saw many of these lawsuits amended to add more registered works. We heard that plaintiffs were about to drop out of a lawsuit completely because their works in the lawsuit weren't registered, or rumblings that lack of flexible registration options was preventing others from filing their own AI lawsuits because they were not able to register their works in accordance with sort of the dynamic way their works are published. So again, the copyright registration system, though, not only benefits authors, right? It doesn't just give these additional things to authors, it also benefits the public. More registration of copyright claims results in more robust public records as to the universe of protected works and copyright claims. And there's more opportunities for licensing and other fruitful market exchanges that can occur with information that you can glean from the public record system. And so a robust copyright registration system, it also helps to bolster the Library of Congress's own collections through the deposit copies submitted during the registration process. But it raises, we look at all of these benefits to both, individuals in the public, but also individuals as creators. But are these benefits really enough for creators to care about registering their copyright with the Copyright Office? Because it is curious to see that the number of total copyright registrations granted have more or less, and then save a few outliers, hovered around 500,000 registrations for the past 20 years. Again, some outliers, but more or less around that range. So it begs the question, why hasn't this number increased more steadily over time? Are there areas within the registration system that we can improve or make more efficient? Do we need additional group registration options? Have the current registration options been working for creators? Do we need statutory changes within the Copyright Act to further incentivize individuals to register and or increase their success rates of securing a registration? Do we even know who is and isn't using the copyright system? And are we identifying those needs? Because again, this is a really important entry point for individuals to participate in our copyright system. So to that point, the Copyright Office hired a chief economist about 2 years ago to examine some of these really critical issues. And in line with the office's strategic plan, several of the initial reports published by the chief economist's office have really focused on the impact of copyright on various populations of the U.S. and various individual groups. So as I mentioned before, again, measuring the level of copyright registration activity is really vital because it's a great way of understanding where these pockets of creativity exist, and which authors are finding it worth their time, efforts, and resources to register their works. So, two reports I want to highlight in particular is, the office's published report on women in copyright system, which showed, that relative to the study participation of women in creative professions, the share of copyright registrations with women claimants since the 1976 Copyright Act has risen in every category of registrable works. So, studying a little bit of the gender gap issues there. The Copyright Office also most recently published a report on the geography of copyright registrations, which examines the geographic distribution of copyright claims registered by individuals and organizations within the United States. So this report is really interesting because it, when accounting for population, it really highlights different locales around the United States, very unconventional or traditionally lesser known locations where there are individuals and companies and communities where there's high concentrations of creative works being registered. So for example, you have Sunbury, Pennsylvania, which boasts Sunbury textiles, and they register a lot for textile patterns. You have Summit County, Utah, for high volume of registrations for artwork that are incorporated into earbuds and earphones. Charlottesville, Virginia, Dubuque, Iowa, for educational literary materials. And then you have other locales like Winona, Minnesota, and Oskaloosa, Iowa, Portales, New Mexico, et cetera, than not New York City or Los Angeles locales. So that's really, it was a very illuminating report because it highlights, these different pockets within the United States that we don't traditionally think of. And you can see how copyright law really matters to local businesses, local communities, and how it positively impacts the individuals within those communities. The office is also apparently looking into where there are so-called copyright registration deserts. So these are places in the United States where there's high levels of creativity, but comparatively fewer copyright registrations, which I think will be another interesting way of seeing, how can we encourage participation by individuals in the registration system. And just a couple other considerations to think about when we're thinking about, barriers of entry and participation within the copyright registration system is a language barrier. So the Copyright Office has diligently been working on providing Spanish language, live assistance in their public information office, translating and releasing circulars and educational materials about the registration process and about copyright law in the Spanish language. And the office is also going to publish a demographics of copyright registrations report next year, which we at the Copyright Alliance were really interested in the report because we have a program called the Initiative to Promote Diversity in Copyright program, where we've brought together volunteers and sponsors from across the copyright community, across the United States, to help Black creators, Indigenous creators, and creators of color register their works with the Copyright Office. So encouraging and promoting this kind of participation of diverse individuals in our copyright registration system is really important. It enriches our cultural and social fabric. It enhances our American storytelling traditions. And it really, again, highlights the impact of the individual on, the overall social fabric. So, talking about copyright registrations may not necessarily be as cool as talking about generative AI, but I figure we are going to probably talk about generative AI today. But it is clear that it's a super crucial and vital administrative function that has a significant impact on an individual, their ability to protect and exercise their rights. So I really look forward to hearing from, my other panelists, views on this topic that we have today, on our registration system, and sort of what questions should we be exploring to enhance participation of the individual in our copyright systems, and then also, the impact of copyright, in helping those individuals flourish.
Okay, so we start out with registration, which provides for individuals a structured ecosystem and one that comes with automatic benefits. It's sort of like, you go, you buy your admission ticket, and you get a drink ticket that goes with it automatically, right? So there's something you get right off the bat. But there's also benefits not only to the individuals, but to the society that we're a part of as a whole. I mean, the fascinating revelations from the Copyright Office of Studies, it lets us know, it's almost as if we were farmers, and it's sort of like, okay, where are the best places to plant? Okay, where are the areas that perhaps we need to, spread a little, get Mtima in there, because he'll put some fertilizer on it, and, yada, yada, yada. So it helps us, right? The structure right from the very beginning. Now you're in the system, okay, and now you have to figure out, okay, how do I navigate, right? And for that, we're going to turn to Mary Rasenberger.
Thank you, Lateef. Is my mic working? It is, okay, the light's not on, thanks. So first, I apologize if you can't hear me well. I'm getting over a cold. It is not COVID. I've taken about a dozen tests in the last week. But just raise your hand if you can't hear me. So as Lateef said, I'm going to talk a little bit about how copyright creates ecosystems and authors position within that as professionals. A lot of authors, I run the Authors Guild, as Lateef mentioned. We have 15,000 members, all writers. We represent the interests of professional writers. We advocate for copyright, free speech, and all other kinds of issues that authors run up against, including and especially fair contracts. So, what I have found is that a lot of authors and other creators, they don't think that much about copyright in their day-to-day lives. They think about selling their work, their articles, their books, which of course means selling their copyrights, but they don't think of it in those terms, and they don't really know that much about the ins and outs of copyright all the time until their work is ripped off, and then they quickly learn a lot about copyright law. But copyright underpins the creative professions. If you think about it, the creative professions would not exist without copyright, and I will go on to argue that copyright is intended, and its main effect is to allow the creation of professions, of experts in the copyright, the creative fields. So, because copyright, it allows creators to invest the time and the money in training, that 10,000 hours of practice that Malcolm Gladwell talks about in Outliers, that's necessary to create great works. In fact, studies have shown that professional authors, people who write for a living, use a different part of their brain than the rest of us. So it is really a talent that is trained as much as natural. Copyright also, as we all know, allows entire ecosystems to develop where others invest in authors. Whole industries have developed around getting authors' works out into the world. But at the center of it are the talented individual creators who worked hard to master their craft. And as Lateef alluded to, they are often underpaid. It is interesting to note that copyright and patents are the only rights that the founders put in the U.S. Constitution. Even free speech, as important as it is to us, was an amendment. So why did they do this? Well, they put copyright in the Constitution. I won't speak about patents, because they understood that authors needed the ability to sustain their livelihood as authors so they could speak their own truths, so they weren't dependent on patrons, government, and corporations, because they saw that democracy would not fully function and the U.S. wouldn't amount to much if we didn't have our own U.S. authors. Copyright is a way of democratizing writing and the exchange of ideas. And you know what? It worked. There were only a handful of American written books that had been published before the first copyright was enacted. Within the next few decades, we had a thriving literary culture in this country, and it has continued to grow. when you have effective copyright systems, and by that I mean laws that are enforceable and enforced, what it means is that you have, as I said, a class of professional creators and the ecosystem that goes with it. That means you've got young people, who love to write, sing, or draw, and they see role models out there, people who do this for a living. They can dream of becoming a writer, a recording artist, or an artist. They often will start studying their art in school, in college. Often they go to grad school in their art. The Authors Guild we survey authors every 5 years for their incomes and other facts, and over 65% of professional authors have advanced degrees. That's really typical for creators. In fact, there are over 250 MFA writing programs in the US alone, and those educational opportunities would disappear without a functioning copyright system. So would the companies and the people willing to invest in the businesses to assist, publish, package, and distribute creators' works. Those would all disappear. In the literary world alone, this ecosystem includes publishers, distributors, bookstores, wholesalers, agents, publicists, freelance editors, book coaches, book designers, and more. They are all part of it. And without the reliance on copyright, there would be no third-party investment. Publishers would not pay the advances to allow authors to write highly researched books and literary works that can take years to write. Some of the books that copyright, I think, was most intended to incentivize because they really provide us with learning and deep thought. Those books, without the advances, most of them could not be written. And the fact is, I'm going to talk a little bit about that we are already starting to see a decline in the number of those kind of books being published in the trade sector. And by trade, I mean the commercial sector, not academic. So sadly, copyright in books has been under attack in the last decade plus, and we're starting to see the impact. And it's because books are so important to learning and culture that many argue we need broader access to books. They want books to be free, online, or at least cheap. So library associations are pushing for cheaper ebooks through state legislation around the country, and even though those laws so far have been found unconstitutional, and they are because they're preempted by the federal copyright law, they're still being pushed. People are still out there arguing that it is so unfair that Internet Archive's open library is not fair use because they want access to those free books. And everyone in the industry, from authors to publishers, we all want everyone to have access to books. It's why the entire industry, and authors in particular, support libraries. And in fact, we wish there was more reading today. But there seems to be a total lack of understanding or care that we also need to be able to sustain the supply side. And I find that so perplexing. It's like, how do you expect authors to keep writing if they can't get paid? When you start chipping away at copyright, you chip away at authors' incomes. Authors are the first to feel it. They are the lowest paid in most industries, and they are the first to feel the chipping away. And if you take away the ability for authors to earn a living, or at least a partial earning, you lose a lot of potential great books, music, and art. So we live this every day at the Authors Guild. Writing has never been a get-rich scheme, but the median income for authors as of 2022 is down to $20,000. That's down well over 40% since 2009, when the Kindle first appeared is a mainstream reading device. And that $20,000 median income is for all writing-related work. It includes journalism, editing, book coaching. Their book income, the median is only $10,000 a year. We've already lost many potential great books because many very good authors have already left the field. It's just too hard. And we're seeing the effect on publishers, too. Many publishers will tell you that they really are relying on celebrity written books and self-help books to turn a profit. And I will say that's the one area of writing that's grown in recent years is ghostwriting for celebrities and rich people. But that's really too bad because it means authors don't get to write their own truths, which is key, as I said, to the kind of exchange of ideas that copyright's meant to support. And I need to say that journalism, things are even worse. It pays so little now for the writers. Newsroom staffs are down by 2/3 in the last 15 years, and those remaining tend to be young because they're the ones willing to accept the salaries that news can afford. More than 1/3, I would say even a half, are freelancers now, and they are paid a quarter of what freelance journalists were paid 15 years ago. Many earn less than minimum wage. There are websites that actually where freelance journalists will put how much they got paid for a piece and how much they earned, and you can see they're getting much less than minimum wage in many cases. So, what does it mean? It means we're losing writers in droves. I mean, who wants to go into journalism today? Except for my son, who is one of those poorly paid reporters. So the plight of news, I will say, is due to the inability of the law to keep pace with new forms of exploitation of creative content. And this is something I want to talk about, I hope we get to today. We allowed social media companies and search engines to take the vast lion's share of advertising money away from the producers of news. And this is not just disruption of an industry. It's a problem for democracy. And yet, we haven't been able to get Congress to fix it yet. Copyright, if you think about it, it's supposed to allow authors to control and profit from the exploitation of their work, at least in the first instance. And initially, it was about the right to copy because that's how you made money from a book. You sold copies. When new types of works were added to copyright and new technologies developed, we added rights. But when we got to the internet era, we pretty much stopped. Okay, we did add a digital performance right for sound recordings, but that's the only one. And honestly, we should have a performance right for sound recordings, period. So, for instance, much of the world in the 90s, under the WCT and WPPT treaties, incorporated communication to the public right. In the US, we saw better than that. We thought our existing rights covered it. It turns out not completely. Now that we have AI exploiting authors' works in completely new ways, we've got to think about this again. And it is really hard to get anyone to think about opening the Copyright Act back up. Training on copyrighted works brings great value to AI companies. We all know that, right? And the output can replace creators. I mean, the potential harm is devastating. In fact, AI has already replaced many entry-level writing jobs, which are how young people get into writing as a career. Outputs, as we know, can be derivative works, infringing derivative works, but they also can take an awful lot from an author in a way that no prior technology could, in the way that no human being can, without necessarily being substantially similar. That is, they're taking value from that work. It is a new way of exploiting authors' works by taking authors' recognizable expression across their entire work. So we talk about it as style, but it's not really style. It is actually expression, but it's expression across a variety of works. And I hate to use that word style because copyright doesn't protect style, and we don't even have a word to describe really what we're talking about. Copyright only protects individual works from infringement, but we're going to have to find a way to protect this new form of exploitation. It needs to be named and it needs to be protected. Thank you.
Okay, that was super enlightening for us because I think, one of the things that we can glean from your remarks is that it's through the exclusive rights that the copyright ecosystem can do what it is intended to do. I mean, you mentioned the old way, pre-copyright, support by patrons, right? And, You came up with funny stories, and as long as they continue to be funny, the king, the duke, whomever, you could continue to stay at their house, right? And then you moved along to the next place. But really what copyright does, and what you laid out for us, is that it encourages individual artists to engage with what you might call expressive dissemination technologies, meaning, for example, the printing press, right? If I'm going to engage with that technology, right, and make things better for myself so that I can disseminate more works, make things better for the public so more of the public can have access to it, I need to know that I'm going to be able to control what happens to my work when multiple copies are produced, when multiple songs are recorded. And it's through the exclusive rights that we're able to ensure the intended benefits both to the individual creative and to society as a whole, because it promotes further dissemination. So we've entered the system. Now we're in the system to see how it benefits us and society. How do we maximize our presence in that system as individual creatives and individual users? And for that, I'm going to turn it over to Jeff.
Great. I want to thank the American Photographic Artists for making it possible for me to be here by covering some of my travel expenses. I believe we're all here as volunteers, and I appreciate that support. So I've really enjoyed what my fellow speakers have said today, and I really think it's wonderful that CIP2 made this whole thing possible. I think it's an important conversation. Artists or creators are not in the business of creating. Creating is not a business. You can create all you want. If there's no compensation to you, that's not a business. That's the art of it. And creators, for the most part, are also not in the business of selling their works. Creators are in the business of licensing the copyright in their works, and copyright remains the only viable path for creators to be able to afford to create new works. And I know this firsthand. I mean, been a photographer for 37 years and had a good time of it. I've really enjoyed doing something that I love and being able to be compensated under the Copyright Act for what I do. And copyright is at the center. It's the flame that burns at the center of my business, and I enjoy the creative part. But I need that business part in order to be able to afford what I do. But my students at the Art Center College, they can no longer afford to be artists. They are some of the best artists I've ever seen that are coming through that program. And they get out and they are fully trained and ready to go, and some of the most inspired and talented people I've ever met. And within 2 to 5 years, they are not artists. They've gone on to do something else because they can't receive the benefit of their copyrights in the current ecosystem and with the amount of infringement that is going on worldwide. And the fact that so many entities are able to exploit and benefit from the creative works of these young creators and of all creators without any compensation going to these creators, in particular in the visual arts space, but in all spaces. But in visual arts, there's no regulatory framework for compensation to go to these artists when their work is used, unlike some of the other areas. And it's also very difficult to identify the creators or identify works, visual works. So it's really challenging. Our bundle of rights to reproduce, to display, to distribute, to adapt, and to perform are the most critical rights that any artist has. And I'm going to take like the 30,000-foot view and try and cover the topics that we're covering here in this particular panel, but I'm going to dive down to ground level on a few topics quickly. So the right to adapt is the most overlooked right out there. People always think of copyright, well, it's the right to copy. Well, it's reproduce, distribute, display, adapt, and perform. And adapt means to be able to create derivative works. And for whatever reason, It's rampant out there that people are just grabbing other people's work and making new works out of those works without any discussion or without authorization. But it's clear from significant cases like Rogers versus Coons that adapting a work in another medium, such as from a photograph to a sculpture, is not permitted unless you're targeting the original work and otherwise satisfy the requirements of fair use. It's common practice for works like books to be licensed for use in a film. There is dramatic difference between the word on a printed page and the resulting film with real people, actors, text that's not, or dialogue that's not in the book, things that are in the film that are not in the book. Just any film has hundreds of thousands or millions of changes relative to the book itself, but for whatever reason, when you have a photograph and then a copy of that photograph that is a derivative work, the courts don't look at it like they look at a film or even at music. They look for minute differences, and if there are a few, it might be deemed not to be substantially similar and therefore not an infringing use. So there's a different judicial standard for the analysis of substantial similarity in different media, and it's unfortunate because it makes it very challenging for creators. That right to adapt, without that, the rest of the rights, reproduce, distribute, display, adapt, and perform, are worthless. If anybody can just take your work, make a few changes, and use it in another medium, what good are the other rights? I'm going to move to fair use for a moment and go down to ground level as well. So fair use is absolutely critical. It's necessary to balance creators' rights with the public interest, but fair use is not a right. It's an affirmative defense to copyright infringement. And unfortunately, it's viewed as a right, and many organizations label it as a right and define it as a right. One aspect of fair use is targeting and critical bearing. The Supreme Court recently confirmed in Warhol versus Goldsmith that absent a compelling justification, a secondary use of an original work that targets the subject matter of the work rather than the work itself cannot be a fair use. Again, unless there's compelling justification. The secondary use needs to target the work itself, not the subject matter. And that's what, even if it's for purposes of commentary, criticism, news reporting, or education, for example, education, textbooks, the #1 marketplace for the licensing of photographs. So mere educational use is not a fair use. Unless you're targeting the work itself. If you want to take one of my photographs and use it to criticize me or criticize the work or review it or make fun of it or any of that, have at it. But if your focus is on whatever or whoever is pictured in my work, that's not fair use. Also, a desire to copy, distribute, display, or perform a work is not in itself a compelling justification to use that work in a non-targeted way. And fair use is a complex determination. Even judges and attorneys have a very difficult time determining what is or is not fair use. How does the public make that determination? They're expected to say, well, this is fair use, and they just think of it in terms of, well, this seems fair, and they don't know anything about the 4 factors, and they don't know anything about circuit splits on how things are treated. So it's a very, very difficult situation, and this results in widespread infringement of creators' copyrights. Now moving over to registration. As Rachel said, it's effectively impossible to enforce your copyrights without a timely registration. Of course, we have the Copyright Claims Board, the CCB, which allows you to register post-registration, but creators find, for the most part, that if they want to enforce their rights and their registration is not timely, in other words, it wasn't made before the infringement commenced or within 3 months of first publication, they can't afford to hire an attorney. They can barely afford to buy groceries. How are they going to support themselves? The infringement has to be massive in order for them to be able to pursue it. But our registration rates, as Rachel said, are incredibly low, and that's because it's very difficult and expensive to register. These are high-volume, low-income creators. A photographer might create 2,000 works to 3,000 works a day. I know I do on my working days. And imagine that volume. It's really like no other type of creator. And having to register that when you're only allowed to register 750 works on a single registration at the cost per registration, it's quite difficult. And the creators are faced with making a determination, is this work published or is it not, when judges and attorneys have a difficult time of making that determination. This is why most creators, and especially most photographers, don't register. We have a lot of hopes for the new system, the enterprise copyright system, that is currently under development at the Copyright Office. And I sit on the Copyright Public Modernization Committee that is involved in that process. And last, I want to talk about public benefits. There's confusion across the public about whether or not I can use a work as a member of the public. How do I know this? Is it in the public domain? Is it protected by copyright? Is my intended use going to be fair use? I don't know if I'm not knowledgeable about copyright. And the solution is education, and the solution is access to information about works, ease of access to information about works. Because once you have information, you can, of course, make an informed decision about whether or not you're going to use that work and how. And in particular, attribution, who is the creator, who is the copyright owner, is essential information to know. It's critical to the public, and it's critical to creators as well.
Excellent. So, in effect, Rachel and Mary laid out for us a system, how you get in, and how that system is supposed to work, how it's supposed to benefit individual creators. And Jeff, you have demonstrated to us how currently that system is not really performing up to par to do the work that it ought to do. And I think one of the things that you highlighted in your talk, has to do with the flashpoint of the introduction of digital information technology and the internet. Before then, right, these problems were not as severe because the average person really couldn't engage in any of the exclusive rights easily, right? You couldn't take War and Peace to the library and say, I'm going to make a copy of it, one nickel per page at a time, right? And now we're in a situation in which people can easily do that without the understanding that the reason why you couldn't do it before was not only that it was impractical, but it was also illegal, right? And so we have that challenge as to how do we repair the system, how do we reinvigorate the system, and if the threat of digital information technology was not enough, oh, you knew we were going to get to it, right? There's this thing called, qu'est-ce que c'est, AI, right? New challenges to further upset the apple cart. Mike, you got the easy task. Solve it for us.
Piece of cake. I'm going to hit resume there to keep myself honest. I'm Michael Murray. I'm a professor at the University of Kentucky. By way of background, I've been teaching and writing about art law and for about over 20 years. And within art law, I write about intellectual property and First Amendment. And within intellectual property, I write about copyright primarily, but also right of publicity and trademark and moral rights and the Visual Artists' Rights Act. I'm going to give you the title of my work, but I have to explain it. I have to put it in context. My title is Lessons Generative Artificial Intelligence Teaches Us About Copyright Limits. The title of this section and the title, I think, of the whole conference is about exclusive rights. So it's my own explanation of exclusive rights through generative artificial intelligence. As Rachel and others have said, we're not going to allow artificial intelligence to hijack this whole discussion, and that's not my intention. But I am using this as a way of pointing out some of the things that we have to learn about copyright exclusive rights. So I would say that generative artificial intelligence highlights the boundaries of the exclusive rights granted to copyright owners. It's very important to understand these rights. We're going to talk about ways, we have heard suggestions of ways that we could reform and maybe strengthen the ability to enforce rights. And that's, a very noble aim and a good aim. But they present a challenge to exclusive rights because they demonstrate the exclusive copyrights are limited. Especially when it comes to broad creative concepts that build on prior creative expressive works. It's a two-way street. Earlier authors their copyrights are limited to their own original contributions, but so are new authors' rights as they build on the contributions of earlier authors. Everyone's rights are limited to things that are not original to them. There's the style and genre. Mary pointed this out very clearly, the style and genre. She said maybe there ought to be a different word for style. I'll come back to that. I like that. But style and genre are excluded. Explicitly excludes the ability to control broad concepts such as style and genre. And that's exactly where generative AI exploits works. It's in a very direct and obvious manner the way that they use the same style and genre of earlier artists. So that's one lesson that generative artificial intelligence is teaching us. And then it has this direct impact on artists' control. Artists would no doubt like to control aspects of their style and genre when they believe these aspects, these visual, noticeable, obvious aspects, come to be associated with them and their body of work. But this is not a concept recognized by current copyright law. Therefore, the artist might feel a loss of control over their creative output as AI-generated works, for example, appear with similar stylistic or genre-based elements in them. So, just by way of background, so we're all on the same thought page here, why are style and genre not protected? But primarily it's because of the originality requirement and the idea expression distinction in copyright law. But secondarily, it is because this is a primary tool that allows copyright, I'm sorry, I keep hitting my mic, that allows copyright to coexist with First Amendment free expression rights. So under originality, style and genre most often are not original to a particular artist. They're the product of learning from the styles, techniques, compositions, and genres of past artists and past works. So works created with the assistance of generative AI do quite well under the originality doctrine because diffusion models, which is the current technology, are designed with stochastic modeling. In other words, they have randomness and novelty built right in. So they do quite well under the originality doctrine. Learning from existing works. We haven't come up with a better word than learning and training for what generative AI does. And so if you look at it like learning from existing works, the generative AI systems rely on lessons that can be learned from a vast data set of pre-existing works, using them as a basis for creating new content. And then, of course, idea versus expression. So copyright law protects the expression of an idea, but not the idea itself. Now, it has never, and everyone in the room can agree, it has never been easy to police this distinction. But generative AI complicates the discussion, if only because the method of creation, when you're creating works through generative AI, the iterative prompting, involves calling for the creation of both expression, in other words, you call for the scene, the image, the subjects of the work, as well as the desired style and genre of the work. You call for fantasy art, impressionist painting, photorealistic image. And so they have complicated this equation when it was difficult enough to separate idea from expression in order to look at that. So we have blurred boundaries now. Generative AI systems are vast data sets to generate works, which the works contain actual expression. But because of stochastic modeling, the outputs generally do not duplicate the exact expressions of works. You can get there, I know. If you're waiting to ask the question of course you can duplicate works. Yes, you can, through very deliberate, tortured prompting, or through very deliberate prompting, you can duplicate works through generative artificial intelligence. But it has to be a direct and intentional effort to force a duplication. But this situation makes it difficult to distinguish between what is protected expression and what is unprotected idea in an AI-generated work. So questions of protectability. The blurring raises important questions about what aspects of AI-generated works can be protected under copyright law, because they're subject to the same originality requirement, right? and can be protected under copyright laws, challenging traditional notions of copyrightable subject matter. Now, of course, we have this, I will call it an interim period. I hope it's only an interim period where the Copyright Office has said basically, if you're using generative artificial intelligence tools, then you're not an artist, you're not a creator, you're not an author. I disagree with that, but that is, of course, I will say that this is the interim position. So for now, the question of protectability of the actual works, when you actually do recognize them as being the work of a human author that is using a tool, then we will again have to get into these other questions about what's original about an AI-generated work. So what is the limit of the copyright? How thin is the copyright versus how thick and broad the copyright is? So the inability to copyright style, genre, or technique under the merger doctrine and the scenes affair doctrine. I liked writing about these doctrines, and they're good doctrines to write about because so few people ever write about them. So it's it's always good. You always get an invitation to a conference if you mention that you're going to talk about scenes affair or merger. The merger doctrine regarding artistic techniques and the scenes affair doctrine regarding stock elements of scenes and images limit what is eligible for copyright protection by excluding elements that are dictated by necessity, as in a certain technique produces a certain outcome. A certain glass-blowing technique, even if it's used in the hands of a great artist like Chihuly, somehow dictates quite a bit of what the outcome is going to look like if you're using this particular artistic technique. Or that they are dictated because they're common to a genre, that being more the stock elements of scenes and images, that's called scenes affair. So like other artists, I know I'm going on a limb saying that, like other artists, generative AI tools, the artists using the generative AI tools, they have a certain impact on what appearances are obtained with certain tools and techniques under merger, and what elements make up standard treatments, scenes, and stock images. But I think we do have to examine carefully and go back in and kind of reskill ourselves as to understanding what does it mean to have stock images and stock scenes and elements of images. Because generative AI work is basically out there looking at the tens of millions, hundreds of millions of examples of what goes into an image of a certain genre or description, a stock image. And then they're recreating a new one. And it is a new one, generally speaking. They often consist of merged elements or scenes affair, so that will be a limit on whatever we recognize eventually to be the copyrightability of AI-generated works. But they're beyond the exclusive rights of any existing artist. And of course, that's the hard pill to swallow for existing artists. But artists have never had the exclusive right to monopolize their genre, artistic style, or techniques under copyright law. Wilkie Collins and Edgar Allan Poe did not get the right to monopolize the detective novel, the crime novel that we now all love, or many people do, just because they were some of the first to make a great success and popularize it. It's beyond the exclusive rights of any existing artist. This section will focus on why copyright law does not extend protection to these aspects and how generative AI exploits the gaps by training on the styles and genres and techniques of numerous artists. So there are gaps. And could they be covered by other rights? And I'll talk about a few ideas I have. The unfortunate answer is not yet to all of these ideas, but I'm going to talk about trade dress, I'm going to talk about moral rights, and I'm going to talk about right of publicity. So when copyright law falls short, artists may turn to other forms of protection, like trade dress, moral rights under Visual Artists' Rights Act, which actually would be much nicer to go under moral rights as envisioned by France or some other country that really believes in moral rights, and rights of publicity. But as I said, the answer, unfortunately, the conclusion I'll come to on each one is these rights do not adequately yet fill in the gaps when it comes to protecting an artist's style, genre, or techniques. So let's take trade dress. To my knowledge, trade dress has not been used successfully to attempt to give exclusive rights to an artist over the style, genre, and general appearance of the works of the artist. There's one existing case, one little lantern floating on the sea of the law, which is Rom Art Creations versus Mtima. It's from 1992. It's a district court level case, Eastern District of New York. And it's a case that discussed the way very similar works that appeared on the market at the same time by Itzhak Tarkay, Israeli artist, and Patricia Govozensky were designed and sold. And we have to be careful to tell you it's how they were designed and sold. So the images of women in cafes, if you're thinking Tarquet, now you're saying, oh, that Tarquet, yeah, right, if you know the work of Itzhak Tarquet. Images of women in cafe were similar, but the court opinion dwells on the layout, the typeface, and the arrangement of the text on the posters that were sold at this time in the competition, in the competing in the market at the same time, and finding a potential trade dress violation. So it did find a potential trade dress violation, but it was more about, as I said, the design, the layout, the typeface, and the arrangement of the text on the posters, not just the fact that they both liked pastel images of women lounging and enjoying afternoons in cafes. Moral rights, again, to my knowledge, has not been used to protect an artist's style and genre, even if a particular artist has become famous for working in a particular style or genre of art. And of course, one huge problem with that, for those of you who understand the United States moral rights, is that the United States conception and enactment of moral rights is very narrow. It imposes a recognized stature requirement that most other nations don't require. It only protects original works, not duplicates of works. That alone makes it very limited. It only protects works regarding their attribution and integrity, meaning misattribution on the actual work or modification, distortion, or destruction of the actual work of visual art. So in theory, a misattribution on an intentional forgery of a work of recognized stature might be protected. But perhaps this is the secret sauce that you're looking for, Mary, when you say, we got to come up with a different word because style isn't doing it. So perhaps by probing this is my thing making a funny noise. Sorry, it's telling me, be honest. You've used up 12 minutes. Wrap it up. Although right of publicity, my third possible theory, is broadly defined to protect well-known aspects of an artist's or celebrity's persona, I am unaware of the concept being extended to the style and genre of the works created by an artist. If the theory were to be entertained, it could quite possibly be preempted by the Copyright Act as an attempted end run around the limits imposed by the originality doctrine and the idea, expression, distinction in copyright law. So even if you think the right of publicity idea is a great idea, it is probably preempted by copyright law. And that is where I'll conclude, wrap up.
Okay, so in addition to the fact that clearly AI is telling you to stop, obviously.
It's just a phone.
Yeah, indeed, so we are being watched. So really, what you've teed up for us is the fact that we see the system that was put in place, we see the weaknesses, and of course, not to oversimplify it, but very much in the same way that digital information technology did the same thing, AI enables not third parties, the public, to engage with expressive works in copyright unanticipated ways, right? Because remember, when at the time of the 76 Act and most of copyright, all the way, throughout the world, the thinking is that, hey, one good reason as to why reproduction ought to be an exclusive right is because not everybody has a printing press in their home, right? Digital information technology and now AI upsets that balance, right? Because with the advent of laptops and the internet, now everybody did have a printing press and a distribution system and a mechanism whereby they could create derivative works in their homes. And I don't even have to make the comment about AI and ChatGPT, right? So with that, it means that the challenges that we've been facing to the system and to the exclusive rights, the ante is even higher, right? And so let's take a chance and see if we can tie this up, since we're running out of time, on a positive note, what all of this has done. One perhaps good thing that AI has done for us is that, as I said at the outset, it has reinvigorated the national conversation about copyright. Right? People are talking about it again, the way that they did, for example, at the time of Napster. What is this? We can't, So is there, and this is open to all of you jumping in any order that you might like, is there something about this reinvigorated conversation using AI as a focal point or not, right? Because the important thing is that people are talking again. Okay, so is there something about AI or just the reinvigorated conversation that provides us with some opportunities?
Yeah, thanks. I like that question a lot because I'm an optimist, and I think you always have to, look at what the bright side of things are and try to get there. There is a reinvigoration of interest in copyright. When we've surveyed our members a couple times about various AI issues, and we have never, ever had so much unanimity around authors' feelings about anything as their belief that training on copyrighted works should not be fair use, should not be allowed in an unlicensed manner. And that, when was it the summer before this past, summer of '23, we issued a letter to AI companies saying that training was not fair without permission, and had 16,000 signatures. And I think, and the statistic of how many authors thought it was unfair in our surveys, over 97%, and the other 2% weren't sure, and only 1% was like, yeah, training's great, it's fine. So it is I think, a re-education of authors into why copyright is important. And one of the things that the Authors Guild does is education in the business of writing. We like to remind authors that, as Jeff said, you're entrepreneurs, you're business people, and you have to treat your writing as a business, and part of that is understanding your copyright. So I think there will be a lot of renewed interest because so much is at stake, and because so much is at stake, the future of our arts. Because, as I said, if we whittle down even more what artists and authors are earning, as Jeff described, we're losing arts already, and we're going to lose more, to the point where consumers will be unhappy. It will become a real issue for everybody. So we will find a way to fix it. I do want to just amend one thing, though, about what I meant by style, that it's not ideas, because I do think this is something that AI does that no other technology is able to do, and human beings aren't able to do. It can capture the essence of a particular artist's writing or their artwork. And it is expression. It's not ideas, the kind of style that I'm talking about, which is why I say we don't have a word for it. In the writing field, we call it voice, right? So it's an author's very distinctive personal voice. And in fact, the copyright law has acknowledged that authorship is about expressing one's own individual personality. So that it's not ideas, it's not genre, it's the expression that you find across a body of work. And in the case of writers, it's how they put the words together. We have a board member who did an experiment. She's a Shakespeare scholar and a romance writer. And she asked GPT to write the introduction to a certain kind of romance novel dealing with X, Y, and Z in the style of 6 different known authors, and then she added her daughter. And it came back with an uncanny, completely recognizable style or voice for each of those authors. And when she showed it to other romance readers and authors, they could guess which one was which. So I think it is something we're going to have to figure out how to protect, and I love all your ideas.
Yeah, I think, again, just taking sort of the registration angle on things, too, of, Lateef, I love how you say that this is an opportunity. Like, I think there's a saying of, in every crisis, like, look for an opportunity. It shows that some of these problems that arose in the age of the internet are just being exacerbated. So, again, just looking at registration as the entry point to enforcement and the ability to actually protect those rights. Again, just focusing a little bit more on the ingestion, training issues, as if, what barriers are there within the registration system? Are there enough flexible options for people to actually, register their works in time to enforce against these AI companies. So I think registration is a huge component. And again, not as sexy as talking about, the ingestion issues of themselves, but a really critical point because we've seen this come up in the lawsuits again. I think, a second part, as I was listening to my panelists talk, that I think is really important for us to kind of focus in on again, is that technologies will survive, even if you have to secure permissions, even if you have to clear rights from creators and copyright owners. I mean, in the age of Napster, I think the fear was, oh my goodness, now we have to license from all these people, and that's the end of music streaming as we know it. And look, now we have a very, vibrant streaming economy, and I think the same fears are kind of being circulated and being espoused by the AI companies, but just realizing that, we talked a lot about sort of individuals in the public versus individuals as the creators, but it's not a versus. They go hand in hand. It can be a very symbiotic, good relationship moving forward, and they're not always in opposite. I think that's sort of the number one thing we try to stress a lot when talking about AI issues in particular. So I think this age of AI has really brought up a lot of the issues that we've been talking about for a very long time, but it's at a different scale than we've never seen before.
Yeah.
Sure. So as Michael was talking, I was taking furious notes because Michael spent a lot of time looking at this issue, and there are learnings to be had from that. And it occurred to me that, I'm a photographer. My clients are art directors, photo editors, creative directors. What do? They prompt me to create things. What do they tell me? I want a dramatic black and white portrait and a sky background. I want, it's identical, nearly identical to prompting an AI platform to generate something, except for there's a human on the receiving end of those prompts. Then I take those prompts as concepts and ideas, and I exercise human original expression to create the works that I'm prompted to create by my clients. That's my entire career and life as an artist, except for the things that I prompt myself to make, right? And so before the 1976 Copyright Act, if I was commissioned to create those works, they would be owned by my client. But the improvements to the 76 Act over the 1909 Act, one of the major improvements from the artist's perspective was that the creator owns the copyright even when prompted, right? Unless there is something in writing to the contrary. So what we're talking about here is somewhat dangerous, including for my peers who are exclusively creating by AI prompting now. What they're saying is the art director who's doing the prompting should own the copyrights. And that is not the case now with any sort of creation, except for maybe by an employee or under a work made for hire agreement or terms. So it's somewhat concerning because those lessons that are learned by the machines are lessons that are learned from my works and the works of every artist who's ever created anything that's scraped up by the crawlers that are going from site to site and scraping up that visual content. I even hate to use the word content. Those visual works, right? And from those, the learnings enable the creation of this work. And maybe that's not a copyright infringement. And the reason why one of the reasons why these lawsuits are not succeeding is nobody's proven that the AI platforms are doing any copying, any actual reproduction in the course of training. Because the AI platforms or people connected with them funded the scraping funded or enabled the scraping of all the content by others before the AI platforms launched, so that they would have databases like the Leon database of billions of works to be able to scrape and use to train. It will be an entirely different law that sits side by side with copyright, I think, eventually that will determine these things, not copyright itself. I don't think it's suited for it. But I want to lastly remind that we're in the very early stages of AI, even though AI has been around for a long time and is incorporated into tools that people already use, long before these AI platforms. Still, we're in the early stages, and the next wave of tools may very well enable the granular control over that allows human original expression. We're not seeing that now, despite iterative prompting. I don't think that's creation. That's my personal view. But the next wave of tools may very well allow that, and that's going to be a whole different story.
Can I just, oh, go ahead.
Oh, I want to be really brief. I'll start out by saying I am a visual artist. I'm a painter. And I also am an author of 27 books, so I have sympathies that are supported by everyone on this panel, and I agree with both the substance of what people have said and the spirit behind it. I embrace the spirit behind it. But one of the examples, and I'm going to just raise it for a learning point there, is you said that somebody was able to, a generative AI was able to reproduce voice. And I'm like, well, that's what authors have been trying to do for generations, is how could I write like the great authors that I admire so much? I study them and I read everything they've written and I try to conform and I try to make my writing look and sound and be like the voice of the artist. And here comes a data-driven, data tool with algorithms, and it's able to eat so much data and find the patterns in the writing that it does it better than human authors do. And that's the thing that makes us both amazed and really angry and disappointed, because it's doing it better than we were able to do it on our own. And I disagree with Jeff on, I think that the human end user is creating the artwork. He or she is using a tool to create art. The tool operates differently from other tools. You don't hold it in your hand. You don't manipulate the screen with your finger as other art tools of digital nature in the past were. But it is, in fact, you with the envisioning and then communicating it into a fixed and tangible medium. That's what I consider to be the copyright creation and the authorship. And it's not done by the AI. The AI doesn't knock on your door in the morning and tell you or Richard Thaler, hey, look what I created overnight. And the guy, oh, my stars, where'd that come from? No, you give the AI the task, you direct it, and then you iterate. Once in a while, you hit one out of the park. Your first sentence comes out just the way you wanted it. But most of the time, you spend much time iterating and iterating to make sure you get what you, the human artist, have designed, and you get it out of the AI tool.
I just want to end on an optimistic note. Thank you for that. Because I actually do think we are moving to licensing for training and for AI use of copyrighted works. There's already been a lot of training, at least training licensing in the text field. We, the Authors Guild, are partnering with collective licensing organizations to enable licensing. And some authors are like, why are you doing that? Why are you getting in bed with AI? Well, because once you have a licensed system, then you can say, once you move from the fair use world, and by the way, we are going to win our case, and we will win many of these cases. Otherwise, it's turning a copyright upside down, and we can talk about that later. But it's going to take a little while to go through the courts. And in the meantime, you want to go to licensing because it gives people control. It gives authors the ability to say, okay, you can train on my work if you give me enough money, but you have to prevent output uses that incorporate my work, and licensees are willing to do that. So, and as Jeff mentioned, we're at the beginning of AI. Already, AI companies are asking for, all kinds of RAG uses, reference uses, types of uses that don't involve training. And of course, there are going to be all kinds of derivative work uses that will provide new sources of income for creators. So it is going to definitely change the marketplaces. But I do strongly believe we will get to a world where it is licensed, and we just have to keep pushing for that. And ultimately, yes, the creative arts will survive.
And RAG is retrieval augmented generation, which is when you prompt the AI and the system goes out and finds the information in response to your prompt, not resulting entirely from its training, but going out in real time to find answers or the source. And another type of that type of use is image prompting. So taking an artist's work and uploading it to a system, and in order to have a visual prompt that then the system will generate a work back based in part on that image prompt.
Well, I think that this is in many ways a positive note upon which we can end, because I think what we glean from this is that in many ways this is just the continuation of a conversation that started way back in the late 80s, early 90s, right? Digital information technology challenged us this way, the internet challenges us this way, and AI is pushing the boundaries even further. I think on the one hand, we all understand that the exclusive rights, they perform a very important function. And that what we're being challenged with now, and what, but you've all said that the current positions are really interim positions, is that we're going to get to a place, hopefully, that in which we will figure this out, how to embrace all of these tools in order to do the things that copyright is intended to do, and not to oversimplify. But I think there are two big things that copyright is supposed to do. It should have a beneficial impact upon the creative efforts of individuals, and it should also have a beneficial impact on the creative sparking within individuals. And the distinction there is that that also brings in people who are not creators, but people who are users of creative works, who will then, as a result of this exposure, ultimately become creators themselves. So with that, as you could see, we could keep going until the Apollo clown comes in and takes us off of the stage. So that doesn't happen. Why don't you join me in thanking our panelists for this wonderful discussion?